Well, thanks for joining us. I know you've been in court this morning, so a busy day for you as well. But we wanted to get your take on a couple of things. So we do know that the defense is getting ready to put on its case. The prosecution has rested in the Sarah Boone trial. And one of the reasons they said they are going to call Sarah Boone first is because they are using the battered spouse syndrome and self-defense. And so can you talk to us about what that is and what they basically have to prove to be able to use that as their defense?
Right. Under the theory of defense, the burden of proof shifts to the defendant. Usually the state has to prove all the elements of the crime beyond a reasonable doubt. But in this particular case, it's going to be the defense job to convince a jury that there's a history of traumatic domestic violence abuse. And there's case law in the past that recognizes that you can use this defense, but the difference is, reasonable is an imminent fear. So we have to convince a jury now that although there is no imminent fear at this particular moment, there is a history of traumatic abuse that led to Sarah Boone thinking in this particular moment that she had no other option.
We heard from James Owens, who is representing Sarah Boone, saying that he typically likes to call defendants to the stand last, if that is what he is, if they are taking the stand. Can you talk to us about the strategy that goes into a defendant testifying on their own behalf? It's not something we see in every trial, but can you just kind of walk us through how that, some of that decision making in whether or not to testify and when?
Well, the rule of thumb is typically for criminal defense attorneys, we don't like our clients to testify because then you subject them to cross-examination by the state. Now, whether you put them first or you put them last, that's a decision that needs to be made. Ultimately, we can make recommendations to our clients, but our clients have the last word. A lot of times we want to be able to put, our client last. So it's one of the few things that, that the jury is going to be able to listen to. Now, just because they put her last or they put her first, they can always recall her back and put her back on the stand. So the strategy might be, let's put her here first. Let's bring the other expert testimony to come testify, and we can always bring her back, right? In case she gets cross-examined and she gets torn apart on the stand, let's bring her back to fix it. Let's bring her back at the end to kind of wrap up the whole case. This type of cases, the jury wants to hear. Again, it's not something reasonable for somebody to be locked inside a suitcase and you're in imminent fear. And that's the key in this type of cases. The question is, you got to convince the jury about the history of traumatic abuse, because the element of imminent fear is not necessarily here in this case.
And so we heard from the defense this morning saying, as they were discussing some discovery issues, talking about body camera video and 911 calls from those from prior incidents that law enforcement had been called to incidents between Jorge Torres and Sarah Boone. So it sounds like you think that is where is that the key now, Jose, for the defense's case?
Right. The key has to be they have to build a foundation of history of traumatic abuse, because again, the state is gonna hit hard on the fact that this gentleman or this victim is locked inside a suitcase. She could have called 911. She could have walked out the door. There's a lot of things you have to do. Typically in self-defense, it's imminent fear, reasonable imminent fear right there at the moment. That's the reason you pulled out the gun. That's the reason you did what you did. Here, if the burden is on the defense, they need to prove that based on the history, she has a different mindset that any other person in that courtroom or the jury does not have. So you have to convince the jury to get in her shoes, in her mindset, and that's why they're going to bring an expert to testify, like to tell the jury. Although you might not understand that there was imminent fear at that particular moment, there is a history which causes her to think differently and see fear in a different manner.
Jose, let me ask you this. I know we talked about the defense having to basically show those elements to be able to use the battered spouse syndrome and self-defense. What happens if Sarah Boone takes the stand and they aren't able to kind of satisfy those elements and prove that? Then what happens?
Well, that's the key in this case, right? So they might come back with something lesser, like a manslaughter or a lesser charge. But in order to get a not guilty verdict in this case, they have to convince the jury. That's a high stake. That's something that they have to do to be able to change the mindset, the thinking of the jury. That's a high task that they're going to have to do. And again, it's going to take some work from the defense, some creativity, It also depends on the expert witness. Is the state going to tear apart the expert witness? Any other case law that they're going to, they're going to move forward. All these 911 calls, all this history is going to come in. And again, a lot of times we see things in court that happen. You got to realize the defense attorneys have to preserve the record for appeal. So he's going to have to object to other things, try to get as much evidence in, because sometimes if the judge doesn't allow that evidence to come in, it could be a basis for an appeal. We always want to set up for the worst scenario, in this case being a guilty verdict. So we want to set up the record straight. We have to object to as much as we can and try to get as much evidence as we can that's going to help our client.
I'm glad you brought that up, because we have seen a lot of these things that have been done, whether it's objections, whether it's the motion for judgment of acquittal that was just denied a little bit ago. How much of this is done with that next step in mind? Basically, in case they do have to appeal. How much of this of what we see is basically looking ahead to an appeal?
All of this is lawyering 101, like the judgment of acquittal. You do it at every single case. Because what happens if you don't do it, then this person gets convicted, they're going to come back and appeal and say the attorney didn't do this, the attorney didn't do that. So what we want to do is preserve the record. Remember, if you don't object, right, what you're doing is setting the record, because you can only appeal when you appeal something, you're appealing the decision of the judge. So you have to appeal, preserve what we call preserve the record. If you don't appeal, you're waiving the right to be able to appeal on that particular basis. So you're going to hear objection, objection, objection. You want to set the record. You want to get as many objections as you can to be able to come back later and appeal in the event that we get a guilty verdict.
All right. Well, a lot of interesting things there to kind of break down. So if you're the defense, then just kind of lay out what your line of questioning would be for Sarah Boone when she takes the stand this afternoon.
Right, it's going to be very tricky, but you got to put her on the stand. You got to set the stage. You got to take her mindset and put it in each of the jury's individual's mindset. You want them to step in her shoes. You want to recreate what happened that day, how she was perceiving things, not how the body-worn cameras or the state's going to perceive. The state's going to say she had an option. She could have walked out the door, but maybe she was under the influence. Her history, she's had a mindset that she had no other option, and that's the reason she didn't open it. And what would have happened if she opened that? Maybe he would have pulled out and strangled her and killed her, and maybe she was intoxicated to the point that she wasn't reasoning correctly, although that's not a legal defense. That's voluntary intoxication, right? But her mindset, her state of mind is what they need to put forth right now, take testimony and take her state of mind on that particular day to justify her actions so that each person in the panel and understand why she did what she did. If they don't buy the story, they're gonna adjudicate her guilty.
Yeah, not a whole lot of. It seems like it all kind of comes down to this, and so I would imagine from the prosecutor's standpoint, they have put a lot of, I would imagine, preparation into their preparation for being able to cross-examine her.
Right, they're gonna. I mean, it's a prosecutor's dream to be able to cross-examine any defendant. They're going to ask her, how much did you have to drink? What were you doing that day? Why didn't you walk out? Why didn't you call 911? Did you not have a phone? They're going to lay out a lot of scenarios of what she could have done that particular day. So they're going to rip her apart. They're going to give her, the idea is to prove that her state of mind is not credible and that she had other options. Again, she's over there drinking the night before with somebody who you feared. Where did that fear arise, right? So you're living with a person, or you go on trip, you see all this domestic violence, they start doing allegations from many years back or months back, but they still go on trips, they're still coming back home. Why? Where did you break off that fear? When did that fear start that night that she had no other option but to open that suitcase?
If this is your client, how do you prepare them for that cross-examination that is probably going to be pretty difficult, maybe even bordering hostile?
Right. We try to prepare our clients as much as we can. We'll set this in. I always get on the other side of the fence. I always play what we call devil's advocate. I always think of the worst scenario. If I was me, I would drill her, ask all kind of hard questions. You got to ask the hard questions. There's this thing that says, as a lawyer, you should never ask the questions you don't know the answer to. So, but in her case, they're going to ask her, how much did you have to drink? You're going to replay the whole scenario. Obviously there's always a little bit of dramatic, she's going to get emotional on the stand. But me personally, we try not to have our clients take the stand. But you've seen that this is a defendant who's had 9 different attorneys. She wants to run the show, and sometimes it can come back to bite them. They don't have the experience. And I've had clients that are in custody for some time, and sometimes when you're in there, you lose the perception of the law, the perception of common sense. And sometimes, she had an offer on this case, she didn't take the offer. So we'll see what happens. And we'll see that if she's adjudicated guilty, the offer is not going to be as good, most likely, that you have to say.
Can that be hard sometimes when you have a defendant who really wants to take the stand and you are advising them against it?
Absolutely. And in our field, usually when we have an offer for this, I hope this attorney has a letter. We usually make him write a letter and sign a release and say, hey, you've been given this offer. If you go to trial and you lose, this is the maximum penalties. Even knowing that, this is our advice. Do you still want to proceed? Still want to, you don't want to take the offer. And a lot of times, they'll sign it and they'll keep moving forward. When we look at it, I always tell my clients is you got to put it on the scale. What's the risk? I've had clients that tell sometimes, it's an 8-year prison versus 7 years probation. So you got to now when you're looking at a maximum 30 years and they're offering you 20 or 25, there's not much to lose. So you go to trial, you flip a coin. But sometimes, you got to look at the risk versus the reward. But I can tell you a lot of times, sometimes when people are in custody for a long time, they lose the perception of the law. There's too many people talking inside the jail, like we call jail lawyers. They lose the perception and they try to the attorneys who run the show. At the end of the day, we work for them. We'll do what they want. But if it's against our advice, we document what it is to make sure it doesn't come back on appeal, because you always hear this story later down the road. The attorney didn't do a good job, or he didn't do what I tell him to do. And the judge, you will see at the end that the judge will ask her, did your attorney do everything that you wanted him to do? And that's why a lot of times you see when you go through different attorneys, we know the law, we know the process, so we try to guide our clients as best as possible.
I'm sure the jury will be laser focused on Sarah Boone and her testimony and what she says, especially because of the kind of inconsistent stories that were given to investigators over the course of this investigation. Those are all things that the jury saw yesterday, so I'm sure they will be laser focused in on what she's saying. But I'm also curious about the demeanor of a defendant on the stand and what we might see from Sarah Boone and how important that might be to a jury. Do you think that's something that is important to them, or that they pay attention to when it comes to a defendant on the stand? And is that something that you tell your defendants, if they are going to testify, to be aware of?
The key is, and I always tell you, got to see if she's a good witness or not a good one. You can have the best story in the courtroom, but if she's not a good witness or he's not a good witness, could be a problem. So yeah, the credit is also, witnesses have to do with credibility. So the issue is credibility. They're going to tear apart her credibility, changing her story. So if you change her story, then you're going to hear the classic story. Why are we supposed to believe you now? Which one are you telling the truth now, or you weren't telling the truth before? So credibility is a big issue, and I'm sure her attorney prepared her for those. I'm sure her attorney, gave her the right, or trained her, I won't say coach her, to be able to give the right answers to those questions. But those are going to be tough questions that she's going to have to address. And again, there's only so much you can prepare your client. At some point, the demeanor of how someone comes through, how they communicate, their actions, how they move their head, their hands, that's something that the jury is going to be looking at, and that's all takes a play in the courtroom.
All right, Jose Rivas, criminal defense attorney. Good stuff as always. We appreciate you joining us and taking time out of your busy day to lend some of your perspective there. So we really appreciate you joining us here on Fox 35 News Plus.
Thank you. Pleasure to be here.